terms of this presentation, it's going to be a little bit different than how I teach, or actually a lot different in the sense that I'm not going to cold call on anybody, so we'll see how it goes when I actually do all of the talking. I kind of enjoy, in terms of my classes, that I can lean on other people to do most of the teaching of the law. Basically, this presentation, as you'll see, is titled Consideration, Examining and Understanding Consideration. Basically, we'll be talking about consideration and some of the substitutes for the doctrine of consideration when it comes to contract formation. In terms of the presentation, really there are three things that I want to accomplish. First off, we're going to talk a bit about the bar examination in general. Secondly, move to an explanation of the doctrine of consideration, and then finally end up with a handful of practice questions. The practice questions are coming around. A sign-in sheet is also coming around. Basically, the purpose of the sign-in sheet really is to get a sense of who's coming to these sessions. So if you're wondering, we're not really taking attendance. We're just curious as to who's actually interested in the subject matter. Okay. In terms of the bar exam in general, I think it's worth spending a few minutes talking about this topic because I know that there's a mix of people in the audience, meaning some people are in their first year, some people in their third year. Third years have definitely probably received a lot of advice on the bar exam. That being said, I think the different perspectives can be helpful in terms of thinking about the bar exam, and I at least wanted to offer a few of my thoughts. In terms of doing that, I really want to do it through the lens of figuring out the topic for this presentation, or the title for this presentation. Initially, I had come up with a very witty title, Consideration, which I thought was absolutely terrific, but Professor Durham thought that it really wouldn't fill the seats the way that apparently I have. So then I thought, well, maybe I could send them some titles to mess with them. These are a few that I actually considered. Applying Kantian moral theory to the doctrine of consideration. I also included going the other, or considered going the other consideration. Yeah, this is a jam. Perhaps reflecting some of the sentiments of the people in the audience. Consideration, oh my gosh, oh my gosh, oh my gosh. Consideration, a presentation for those who failed to learn from my colleagues. Obviously, anybody who doesn't understand consideration could have possibly actually been in my course. Unfortunately, this is being videotaped, so my colleagues could actually watch this. So maybe I should be worried. But we'll get to why that is a joke. Consideration, how to bluff your way through a bar examination with answer, which didn't seem like a very good approach to this topic. Consideration, what do you mean I can't cold call on people, which I found very upsetting when Professor Durham informed me that I probably should do a lecture. The corollary of that is consideration, what do you mean they're videotaping this so I can't pace obsessive compulsively across the classroom? Which for those of you who've had me, probably watched me walk several thousands of miles in terms of the classes that you've had me in. Consideration, a presentation to attend because you got nothing better to do on Friday, which didn't seem to be in the spirit of things. And my personal favorite, consideration, a word that law professors don't understand, so they made up another definition. Which is a joke, but apparently not that funny. In terms of thinking through those topics and why some of them weren't appropriate, consideration, when you're thinking about the bar exam, just using that type of simple, short approach to things really is not appropriate, in the sense that the bar exam is about gaining a sophisticated understanding of the law. Meaning that, beyond just a surface understanding, you are going to have to actually understand something about the law. I say this for very specific reason because when I took the bar exam, one of the people who I actually was a lecturer during it, basically informed everybody that you only needed a really shallow understanding. One of my friends took him seriously, and then one of my friends saw him again the second time that he actually took the bar exam. So, definitely I would keep that in mind. In terms of the second title that I had actually thought about, Applying Kantian Moral Theory. I think it's important to remember that the bar exam is not about theory. And what I mean by that is I had another friend who basically was of the opinion that he was going to teach the bar examiners something about the law, and then he got the opportunity to have discussions through his essays with the bar examiners 3 times before he actually passed. So it really is about the law itself. Consideration, yeah, this is my jam, which actually was pretty catchy and I considered for a while, and I sort of wondered what Professor Durham would have done if I just sent that to him. But really that stands for the proposition that the bar exam is something worth taking seriously. And what I mean by that is after you've spent all the money, time, and energy to take the bar exam, it's one of those things that you don't want to repeat. And really the time and energy that you put in the beginning in terms of working on the bar exam or working through the subject matter tested on the bar exam is going to be worth the effort, meaning that you're going to feel better as things progress, the more energy that you put forward. That being said, I mean, there's certain people out there who may be thinking, well, I don't even know that I want to be a lawyer, I have a guaranteed job, I'm not sure what I'm doing after graduation, so I'm not that invested in it. Ultimately, how well the school does on the bar exam does reflect on the value of the degree. We have struggled recently in terms of that. But that being said, it is something that we should be taking seriously as a community. And hopefully everybody is thinking of a member of that community will do just that. This title that I considered, Consideration, oh my gosh, oh my gosh, oh my gosh, really is the wrong mindset when it comes to the bar exam. The bar exam really is about race under pressure. And what I mean by that is everybody who I've ever talked to who took the bar exam, there was something on it that they swore that they had messed up. There was something on it that they had been promised to them by their commercial preparation service that would not be on the bar. And everybody in the course of the bar exam felt as though there was something that they weren't adequately prepared for. In terms of that, a lot of how well you ultimately end up doing on the bar exam is how you are how resilient you are in the face of that feeling of oh my gosh, oh my gosh, oh my gosh. Meaning that on my own bar exam, I was promised that there would be no immigration law included on it under the constitutional law topic. I opened up the book for constitutional law, and there it was. And one approach that I could have taken was basically to curl up into a ball. But really, just taking a deep breath and moving forward is what you have to do in those circumstances. Consideration of presentation for those who failed to learn from my colleagues. Amusing, but that being said, that's really not what you're doing in terms of your bar review courses. Review is a necessary part of bar preparation. And what I mean by that is that there are some people out there, and some of the people that I went to school with, who basically said, well, I took all of these courses, don't I know enough for purposes of passing the bar exam? Do I really need to take a commercial preparation course? The answer to that question is yes. Meaning that, for example, if you want to become an expert on Star Wars, how you get to be an expert on Star Wars is watching Star Wars a lot. In the same way that if you want to be a concert violinist, how that actually occurs is through lots and lots and lots of practice. There's a lot of research out there these days. Jeffrey Colvin, who recently wrote a book called Talent is Overrated, basically what it suggested is the more you practice things, the more time you spend with subject matter, the better you are going to do and the more successful you're going to be. The next title that I basically discarded was Consideration, How to Bluff Your Way Through a Bar Exam Answer. Definitely not the approach that we should take. The bar exam is really about an opportunity to fill in the gaps in your legal education. And what I mean by that is when I went to law school, definitely there were topics that I knew better by the time I got to the bar exam. Part of that was that there are a lot of things that are covered in the course of law school, and it actually takes some repetition to get things into your head sometimes. Part of that is too that some of my professors actually made decisions about what to cover in their course that weren't necessarily key to what was on the bar exam, or in the alternative, they didn't have the opportunity to actually cover all the subject matter. But the bar exam is an opportunity to fill those gaps, and it's definitely worth taking a commercial course as part of doing that. In terms of the next topic that I decided against, consideration, what do you mean that I can't cold call on people? Really, I think that stands for that proposition that the bar exam is about topics that you already know something about. Meaning that at the point where it comes down to some amount of desperation on your part as to how will I get all of this into my head, there really is, we really have learned a lot in the course of law school, and I think it's very important to remember that. And then consideration, a presentation to attend because you have nothing better to do on a Friday. Really, the thing that has to be acknowledged here is that the bar exam is going to take sacrifice. And I'll say this, and I guess I'll tell this story. I'll say this. In terms of thinking about the bar exam, you not only have to prepare yourself, but you have to prepare the people around you. And what I mean by that is that definitely in terms of some of the people who've had issues in the bar exam in the past, it's been one of those things where they haven't been ready for the stress that it would create on their relationships, and the fact that people who are in those relationships on the other side of them simply would not understand what they were doing. Meaning that I had a student a few years ago whose husband became convinced that she was cheating on him because she was spending so much time with the Barbary books. Ultimately ended up being dissuaded of that, but at the same time, taking time to prepare yourself and prepare those around you will be worth the effort. In terms of this topic, consideration, a word that law professors don't understand, so they made up another definition. That one's just completely true, I just threw that. Actually, that's not true. The thing that you'll find if you talk to people in the building is that the law school faculty, the people that are involved in bar support here, really do care about you passing the bar. And uniformly, and I can say it uniformly because it's a topic that we discuss very regularly at the school, we are very committed to making sure that you have the proper tools. Definitely in terms of thinking about the courses that I teach, whether or not it be business organizations, criminal law, contract law, I am very happy to talk with you if you have questions as you prepare for the bar exam. Shoot me an email and we'll find a way to communicate. And really, there are a lot of people when it comes to the people at the school who are rooting for you and rooting for you to pass. So, ultimately we end up with this title, Contracts, Examining and Understanding Consideration. Really, part of the reason why I chose the title and thought it was good for this presentation, because the bar exam is about calm and cool mastering communication through law. From all this, you end up with a pretty good list of things that we should be thinking about in terms of bar preparation. Really, the three main takeaways are that you are going to want to master the law, you are going to want to be able to communicate the law, and the thing that I felt that I really wasn't ready for, prepared for when I studied for the bar exam, you want to prepare yourself and those around you psychologically for your bar experience, meaning that this will be a different sort of experience than others that you've had in law school. Almost to the point where people who've taken the bar exam, invariably they tell you it's easy because they've blocked a lot of the study and the stress out. That being said, I did find the bar exam to be kind of easy, which is a joke. Really what I found the bar to be was rule, meaning that you have to have the spirit of a marathoner to excel at the bar exam, and definitely I would take that mindset. Meaning if you start off in a sprint where you're not sleeping the first few weeks that you study for the bar exam, that's not going to pay off. But you really have to think about distance performance where you are making maximum use of the time that you have available. In terms of that, definitely it's important to remember the stress in the moment seems like it's going to last forever. And definitely I think it's important if you're talking to people around you, if you're not going to be able to see your friends for a while, make the promise that after the bar exam wraps up, you will find them and experience a level of debauchery that's only written about. Which I am just kidding. Or maybe I'm just saying don't get caught, I'm not sure. Anyway, an explanation of the doctrine of consideration. In terms of preparing this presentation, the place where I started, and actually something that I consider in terms of the preparation of my class and what I actually cover in my class, I took a look at the outline of subjects that's provided by the National Conference of Bar Examiners on what they intend to test in the bar. In terms of that, they provide the following in regards to consideration as to what they actually will test. The thing I will say is you will see consideration on the bar, and it is very likely that you will see the topic of consideration multiple times, meaning that not only will you see it on the MBE, it's extraordinarily likely that you will see it in the essays of whatever state you are taking. In addition to that, it's one of those things that potentially will show up in an MPT question that are used in many of the jurisdictions, I think 38 or 39 throughout the United States. In terms of thinking about consideration, we have the following definition. Consideration is the bargain for exchange of legal value, i.e. it's the permissible subject matter of a legal contract. Meaning that if you're going to strike a bargain, if I walk into the room and I say, hello, do you want to have a contract with me? And the other person says, oh, yes, it would be wonderful to have a contract with you. We have no bargain. And the reason for that is there is no subject matter of that actual agreement. In terms of the elements of consideration and the things that you should be concentrating on for purposes of the bar exam, they're twofold. First off, you want to look for a bargain for exchange, meaning that in terms of thinking about consideration, there has to be a bargain and there has to be something given by both sides. In addition to that, you want to ensure that there is actual legal value, meaning something of worth actually is being exchanged. In terms of talking a little bit more about the bargain for exchange, probably it's useful to talk about the circumstances that are commonly tested on the bar exam where you will not see a bargain for exchange. The first circumstance are gifts, meaning that in a circumstance where it's Christmas or your birthday, you are not getting a collection of contracts, and that's something that you should clearly remember. And the reason for that really is there is not an exchange that is going on or a this for that type of exchange. Probably you should think about your birthday more because generally you're not getting presents back at all. So there's not any exchange at all. The second type of situation where there is not a bargain for exchange is the past consideration type of case. This would be the case where somebody does something for you, meaning that, for example, they paint your house, and then after the fact, they come and they ask you whether or not you will pay them $1,000. There's no legally enforceable contract, meaning that unless you have some sort of contemporaneous exchange, some sort of this for that, some sort of negotiation, although it can be a very basic negotiation, you don't have a bargain for exchange for purposes of consideration. The third type of circumstance in terms of which there is not a bargain for exchange, in which the bar examiners commonly test, is illusory promises or circumstances in which you have agreements that lack mutuality. And what I mean by that is in terms of thinking about consideration, and this is what sometimes trips people up, both parties have to be actually bound to something. And what I mean by that is that, for example, if one party says, go ahead and do the performance that I've requested, and then I'll decide what I want to do, there is no contract. That being said, in terms of thinking about that bargain for exchange, even something that is even something that's conditional or contingent can potentially be a bargain for exchange. To provide an example of that, for example, I hire an artist to paint a picture of me, and ultimately what happens is that the artist, that I tell the artist that I'm only going to pay if, in good faith, I determine that the artist has satisfied my artistic taste. That type of situation, you actually can have a contract. And the reason for that is that you are bound for something, bound to something. And what I mean by that is that because you have good faith coming into play there, ultimately, and you can prove in certain regards whether or not somebody is acting in good faith, I am bound, even though it is conditional upon my approval. So in terms of thinking about the bargain for exchange, it very much is a relatively loose topic or concept, but that being said, gifts, past consideration, and circumstances where a party is bound to nothing, those are the things to look out for purposes of the bar exam. In terms of thinking about legal value, it can either be performance or promise, meaning, for example, if I offer to pay somebody $1,000 if they will walk to Xenia, Ohio, consideration of the contract, bless you, can either be them actually performing the act, meaning walking to Xenia, Ohio, or in the alternative, promising to perform the act. Either one of them can be valuable consideration for purposes of thinking about whether or not there is a binding agreement. In terms of thinking about that, you have to have some sort of legal value in terms of the transaction. And what I mean by that is that, say, Dean McGreal becomes concerned about my behavior at the school and offers to enter into a contract with me for $1,000 if I promise not to hack people to pieces with a samurai sword. In fact, that is not a legally enforceable agreement. Why, you might ask? The reason for that is I don't have the legal right to basically hack people to pieces with a samurai sword, meaning I've offered no legal value in that particular circumstance. I have to be bound to something. Sometimes the term that's used is I have to be suffering some sort of detriment by entering into the contract. And really the detriment can be any sort of restriction of my actions. For example, with the painting hypothetical that I gave, really I don't have as much freedom as I possibly could, because in that circumstance I've agreed to do something if the picture actually conforms to my good faith approval. Okay. In terms of thinking about consideration, courts will generally not review the adequacy of consideration, but sham consideration is likely no consideration at all. And what I mean by that is that courts do not want to get into the business and have refused to get into the business of basically second-guessing people's deals. Meaning that just because you struck a bad deal does not mean that there is no consideration. I mean, just because you opt to pay $1,000 for a painting that might be worth $100, a court is not going to second-guess that particular transaction. That being said, there is a class of transactions where courts will get involved, and that's the so-called sham consideration type of circumstance. And really, for those type of cases, what you're looking for is a payment of some sort that is drastically out of proportion with what is being given on the other side. In terms of thinking about that, you are looking for a circumstance where somebody agrees to pay $1 for $1 million house. You are looking for a circumstance where somebody agrees to pay a penny for $100,000. You are basically thinking about the question of whether or not there really was a mutual assent to be in an agreement, and that tends to be the rare case. Even if I strike a dramatically bad deal, for example, if I sold my previous car for $20,000, which nobody should ever pay for it, a court will not hold that there's sham consideration there, but will find the consideration actually exists. In terms of thinking about substitutes for the bargain for exchange, meaning that there are exceptions to the two elements that we've seen. You'll need legal value being involved, but there are circumstances in which there may be substitutes for the bargaining process. The first is promissory estoppel. Promissory estoppel definitely can be a claim unto itself, but in certain instances, courts will actually use it as a substitute for consideration. In terms of thinking about promissory estoppel, probably Restatement Second of Contracts, Section 90 provides the best definition for it. What you are looking for is a circumstance in which you have a promise in which detrimental reliance upon has occurred, and the detrimental reliance actually has to be substantial. You are looking for a circumstance where basically somebody has relied on a promise and been hurt by it. Moral obligation also potentially can be a substitute for the bargain for exchange. It may be one of the circumstances where you have a particular matter that looks like past consideration, but courts actually will enforce a contract. Generally, in terms of thinking about moral obligation, it's a circumstance where somebody does something for somebody else and there's an expectation that they will be paid for it. It is often used in circumstances in which there are emergencies. For example, a classic case, somebody happens to be cleaning out a mill, is pushing a large wooden block off the top level, and as a result, or at the point that they're about to push it off, they realize that somebody is walking underneath it. They fall with the block and hurt themselves. The person who basically has avoided the injury agrees to pay them a certain amount of money for it. Courts in that circumstance sometimes will actually find an enforceable agreement. Sometimes you see this tested on the bar exam. It tends not to be. Probably in most instances, the vast majority of instances in which you see a past consideration type of circumstance, the best answer will be that there is no contract at all. Okay. One of the two other issues that we need to talk about for purposes of bar passage, first off, modification of contracts, basically pre-existing legal duties. The default rule is that performing or promising to perform an existing legal duty is not sufficient legal consideration. Basically what that means is if I happen to be doing work on your home, and I come to you and I say that rather than paying me $1,000 a month for that work, that you're going to pay $1,200, and I offer you nothing else, in that circumstance, the new contract or the modified contract for $1,200 is not legally enforceable. There are exceptions to this general rule, and actually quite a few of them. You can have a circumstance where there is new consideration. What that would be is if I'm doing work on your home and ultimately you decide that in addition to having me work on the house, you would also like me to make modifications to your garage. We can agree on a new price, $1,200, and basically you would have a modification of the original contract. Second circumstance, unforeseen circumstances. This basically would be the circumstance where you've asked me to dig a swimming pool for your home, you've settled on a certain amount of money, and I discover once I start to dig that there happen to be gas tanks there from an old fuel station, and I have to go to or basically have a new burden or an unforeseen burden placed upon me. In that circumstance, we can modify the contract for the higher price. Notably, and this is really the one instance that's important for the bar exam, or the major instance that's important for the bar exam when it comes to the difference between goods and services, meaning that this is the circumstance where the UCC applies or departs from the common law. A good faith agreement to modify a contract basically is legally enforceable without new consideration. For example, if you agreed to ship me a shipment of bobblehead dolls for $1,000, it becomes clear that what I really would have liked, or the amount of money that really should have been used, is $1,200. it's perfectly permissible to have the contract modified for that $1,200 amount as long as both parties agree. No new consideration is actually required, but you have to be dealing with goods in that circumstance, meaning it's an exception that relates strictly to goods. The rule that we looked at, of course, applies to all things that are not goods, meaning services, real estate, tax. Okay. The fourth exception in terms of modifying or exceptions to the pre-existing duty rules rule, basically circumstances in which you have some sort of pre-existing legal obligation that is now barred by law. Meaning that you actually, once a legal right that was established under a contract was extinguished, it actually can be revived in certain sorts of circumstances. The three that are most commonly discussed, to pay obligations barred by the statute of frauds, to pay debts incurred by infants, and to pay debts dismissed in bankruptcy. All of those are circumstances in which there has been a previously negotiated agreement, and what you are doing or how you are modifying that agreement that's now legally barred is basically by reviving. And the fifth exception to the legal duties rule basically is the settlement of honest disputes, which I want to talk a little bit about because it is a topic that's commonly tested. In terms of compromise and settlement of claims, or accord and satisfaction is the legal term that you commonly see. Basically, the settlement has to be made in good faith. And secondly, the claims underlying the settlement must have some foundation, i.e. there must be a real dispute over liability. Meaning that if there's a circumstance where one party basically knows that they're liable, knows that the other party desperately needs, for example, the goods or services that they happen to be applying or happen to be supplying. In that type of circumstance, if they in a sense, blackmail the other party to pay a greater amount, there is no new legally enforceable contract that is formed. And what I mean by that is in a circumstance in which one party basically, or both parties know that there isn't an honest legal dispute, the party that claims, there's a failure of consideration in the sense that one party is given something but the other party gives nothing. There's no honest legal dispute there to give up. There's no legal right that they're giving up, going back to our definition of consideration. Okay. So for purposes of the bar exam, those are the topics that tend to be commonly tested. Does anybody have any questions over that? In terms of this lecture, it actually will be posted online. In addition to that, the extra materials will be up in the faculty secretary's offices on the 4th floor. And the associated slides, redacted of course, arguable insults against my clients, or colleagues, will be removed of course. But the slides will also be available if you want to look back at them, which they're not really insults. They're more jokes. With a grain of truth. Anyway, why don't we take a look at a few practice questions. Does everybody have the sheet? Does everybody have a copy? Okay. I think the best thing to do is to allow everybody a minute or two to take a look at question 1, and then I'll talk through what the correct answer is. I definitely don't intend to call on people other than generally ask what people's opinion as to what the correct answer is when it comes to these questions. So let's take a minute or two. So we have a hypothetical here. We have Methuselah basically making a will or promising to make a will to leave his chinchilla ranch to Noah. And Noah replies, "Thanks, Grandpa, I'll make you proud." Right? Show of hands, who thinks the answer is A? B? C? D? All right, this is going well. Awesome. Okay. In terms of thinking through the answers, A is pretty clear that one does not apply, basically because Methuselah did actually suffer a detriment because he promised to do something. B, it's pretty clear that that answer does not apply because moral obligation, we know, is only in the rarest circumstances a subject or a substitute for consideration. So what that leaves us with is the fairly common circumstance when it comes to multiple choice questions where you're able to narrow it down to one or two answers. I definitely think it's a good process in terms of thinking through a multiple choice question to basically go through, closely read all the answers, because I know that I was guilty of this at times when I took multiple choice questions or tests. You know, I get really excited about answering questions. I knew that I only had a limited amount of time. I'd see something that was sorted right and I'd just mark the answer. So it pays to read everything. Go through and mark out the ones that happen to be clearly wrong. So that's A and B. That leaves us with the B and C answers. B, no, because Noah's promise to make Methuselah proud did not induce Methuselah to promise to will the chinchilla ranch to Noah. Sounds plausible. I mean, we know that the definition of consideration is based on an exchange. But then you read C, no, because Methuselah did not seek Noah's promise or performance in exchange for Methuselah's promise to will the chinchilla ranch to Noah. We see language that is based on our actual definition of consideration, that notion of bargain for exchange, and obviously that ends up being the best answer. The thing I will say, multiple choice questions are extraordinarily hard to write. Usually in most instances, there'll be at least one clearly wrong answer. Sometimes people's response to that is saying, well, okay, that's clearly wrong. Well, obviously I missed something. Sometimes that is true, but in most instances it means that it should be dismissed. Usually, and especially with the bar exam, the questioners tend to try and be tricky, meaning that taking the time to read all the answers pays off because there will be a close call. And that's essentially what you see between the B and the C answer, a close call between the two. Okay, let's take a look at the second question. I'll give you a minute or two to look at that. And I will say B is not the correct answer. It deals with topics that we really haven't discussed in terms of our discussion today. Okay. Who thinks the answer is A? Who thinks the answer is B? C? All right. The answer here definitely is A, meaning we have a situation where basically Methuselah promises to make a will or to will the chinchilla ranch to Noah. Noah would promise to refrain from drinking, gambling, and speeding for the rest of Methuselah's life. In terms of thinking about that, D, we've of course marked off the table immediately because it deals with other subject matter. B, no, because Noah suffered no detriment from his promise to refrain from drinking, gambling, and speeding. Sounds like detriment to me. It was a joke. But, serious. There is detriment, meaning that basically he has limited his legal options. And what I mean by that is even if Noah happened to be somebody who had never engaged in drinking, gambling, and speeding, and really never intended ever to do that, he has limited his ability to do something that he is legally entitled to do. C answer, no, because Methuselah realized no benefit from his promise to will the Chinchilla Ranch to Noah. Courts do not look at the benefit to the actual benefit that is incurred to the parties. And what I mean by that is a court after the fact won't say, oh, you struck a bad deal where there was no benefit to you. The question really is whether or not there was an exchange of things that are legally valuable, or in a sense there was a detriment to each party in terms of them limiting their actions or their ability to do certain things. The fact that this actually may have benefited Noah really doesn't matter. The fact that Methuselah didn't actually receive any financial benefit doesn't matter. There really is the exchange of legal value that you need. So the correct answer is that. Let's take a look at question 3. I'll give you a minute to look at that. Who thinks the answer is A? B? C? D? Feeling pretty good about life. You already understood this. I'm going to take full credit for it. Okay. Ultimately, we have a circumstance where Arnold basically already owed Benedict $500. The parties didn't dispute it. Arnold basically says, okay, I'll pay you if you paint my car. Standard type of modification case where where basically Arnold is trying to get something else that he didn't bargain for in the original contract, and basically there is nothing else being offered for that, meaning that there's no additional consideration being offered. Let's take a look at question 4. A, B, C, D. Okay. In terms of this, the answer is actually D. The reason for that, we have a situation where basically the notion is that there is a $500 underlying debt and the offer is to pay $750 in the event that Benedict will actually repay the car, meaning that basically the total debt will be paid. And it's a question of whether or not there is a modification of the underlying contract. What I mean by that is that this is a circumstance where you really can modify an underlying contract because you have consideration being given from both sides. And really the trick in this particular circumstance is to figure out whether or not, for purposes of the modification, both parties are giving something. Meaning if both parties are not giving something, you don't have a new contract, you do not have consideration. C, which a couple of people mentioned or answered, yes, because the price Arnold promised to pay equaled the amount of his outstanding debt plus the fair market value of Benedict's services. Fairly close call. That being said, after you eliminate the A and B answers, you're down to C and D. D, yes, because Benedict promised to repay Arnold's car in exchange for Arnold's promise to pay Benedict more than $500 Arnold already owed. Basically, the reason why that's the better answer is it puts things more in terms of the formation of a contract question. Let's take a look at one last example. Let's take a look at number 5. A, B, C, D. Okay. What you ultimately see here is basically a circumstance in which there is a promise to make a will, or there is the existence of this will, or a promise to make a will. And thereafter, the daughter comes and visits regularly. Ultimately, D ends up being the best answer because there's not a bargain for exchange that is going on that you need for purposes of consideration. Somewhat of a close call as to whether or not you can make a promissory estoppel claim, but she really wasn't giving that much, so D is the best answer. Meaning that this is one of those types of questions that you will see on the bar exam where there may be a slight argument for something, but when in doubt, look for the strongest argument. And this is very clearly a past consideration style of case because she really didn't do anything until after. I put a pile of the answers to the other multiple choice questions up here that you can grab on your way out if you're curious about them. They pretty much are the ones that we looked at. Thank you for everybody for coming. I do honestly and sincerely mean that. Definitely the faculty appreciate your time and energy in preparing for the bar exam. And in terms of thinking about that, definitely the time and energy in the long run will pay off. So thank you everyone. If you have questions about contract